Joe DeGenova, please.
Well, I was here a year ago, and I was here to praise Caesar in the form of Judicial Watch, and let me do it again, because as a result of the indefatigable activities of Tom Fitton and Judicial Watch, we have learned some amazing facts about the conduct of official business by the United States government, and particularly the Secretary of State and her entourage. Some of the most revealing and astounding bits of information about the conduct of government at the highest levels, so disturbing in their extent and in their implications, as to really put into question whether or not a person who did what Hillary Clinton did should ever be president of the United States. Let's settle a few things at the outset. Mrs. Clinton continues to say that this is a security review that the FBI is doing. That is nonsense. It is also false. Mrs. Clinton, by the way, has given mendacity a bad name. It hardly seems possible for anyone to have lied so much about so many things of such import, but she continues to do so, and she does so with vigor and impunity. And you have to ask yourself whether or not the type of Nixonian paranoia which led her to set up the private server really, really disqualifies her from the highest office in the land. The second thing is the criminal probe is underway. And when I was here last year, I said there would be one. I also said there would be a grand jury. There is a grand jury. I also said, because Mr. Pagliano, who was the guy that worked for her at the State Department and also worked for her privately, and of course, as you know, he never told the State Department that he was working for her privately, and that's one of the reasons he's been given immunity, because he lied on his forms to the State Department about what his relationship was with the Clintons. There is a damage assessment underway in the intelligence community about all of the emails that are classified, but more particularly, there is a damage assessment underway, an official damage assessment, which you have to do before you bring the cases that are going to be brought in the criminal investigation. And that damage assessment is to determine exactly what you're supposed to do when you know that very, very valuable classified information has been compromised. And make no mistake about it. The Secretary, her entourage, Cheryl Mills, Patrick Kennedy, the Undersecretary for Administration, and all of her staff engaged in a conspiracy to withhold information from the American people, Congress, and the federal courts under the Freedom of Information Act, under congressional subpoenas, and under general litigation. They engaged in a conspiracy to obstruct the administration of justice in federal courts. That is now coming to light. Last year, I predicted that declarations and affidavits from Mrs. Clinton and her staff would ultimately be insufficient. That has now come to pass. She is going to have to testify, and her staff are going to have to testify. Needless to say, they've already lawyered up for other reasons, but they're going to need them even more. She has continued the lie that Colin Powell, Condoleezza Rice, and Madeleine Albright all used private emails. What's the fuss? And as Jason has said, the fuss is that she set up a private email in her home, in the basement of a house in Chappaqua, New York, to conduct all her government business. That has never been done by anybody in the history of the United States government. And for her to continue to float the nostrum that everybody did it is truly pathetic. It also tells you something about the ineptitude of the American mass media, which continues to report it uncritically. Let's put it this way. Last year, I said that the purpose of the private email server was to destroy history. Hillary Clinton wanted to hide, delete, evade, prevent the disclosure of official government activity. The way she did it, and the people who did it with her, who lied to federal courts about whether or not they had information, is a crime. There were crimes committed in front of Judge Sullivan in the form of false statements, and ultimately that will be part of the criminal case that the Justice Department has to review. And let me just say something now about that process. On December 28th, I gave my New Year's predictions on my regular legal commentary on WMAL. And on that date, I predicted that Hillary would never make it to the finish line. I mean, it doesn't matter to me whether she does or not, but as a legal matter, she won't make it to the finish line. And the reason is that no honest FBI will ever not bring criminal charges in this case. There are going to be referrals for a series of criminal charges involving violations of the espionage statutes, the grossly negligent mishandling of classified information, the grossly negligent storage of classified information. Remember, her server was unencrypted. It had nothing to do with the United States government. It had no software in it to protect it from foreign intrusions or any hackers. A 14-year-old in Secaucus could have gotten into that computer. All of the devices that she and her staff used to communicate with that server were unencrypted. That means wherever they were in the world, when they were talking with one another or to other people, any intelligence service worth its salt was inside those machines and those devices. Michael Hayden, the former director of NSA and former director of Central Intelligence, said, and I like his phrase, the original sin of this case was the placing of that server unencrypted in a basement in Chappaqua, New York, for the conduct of all of her business and that of her staff. There is no doubt that the information, especially the information on the 25 top secret emails, special access programs that no one will ever see because they are so sensitive, went through that server, was in those devices, and foreign governments got them. As Michael Hayden said, if I were running a foreign intelligence service and I found out that Hillary Clinton had a private server, the next day I would have everything that was in that server on my desk. And don't you believe that a number of foreign intelligence services didn't do exactly that. When this is over, the FBI will make a recommendation to the Attorney General that Mrs. Clinton and her entourage be charged with a series of federal crimes. They may not recommend felonies as a courtesy to a woman who was the First Lady for 8 years, a Senator, and Secretary of State. They may, as a courtesy, try to do what they did with General Petraeus and recommend misdemeanors. But make no mistake, they are going to recommend that she and others be charged with crimes. It will then be up to Loretta Lynch, the Attorney General, to decide what to do. If she's smart, and she appears to be, she will appoint a special counsel to make that decision rather than take it on herself. Because if she were to decline to bring a prosecution based on the publicly available information, she would either have to resign or she would be impeached. And I don't use the word impeachment lightly. This is a very serious matter. We have the person in line to be President of the United States as Secretary of State who set about at the beginning of her tenure in 2009 to subvert the transparency of the United States government, to compromise national security, and then to lie about it repeatedly and laughingly. This woman is not fit to be President of the United States. And if the FBI recommends, as I know they will, criminal charges, the Attorney General has an absolute duty to pursue the matter and to bring criminal charges. We shall see what happens. This is a complex problem for the Justice Department. The Civil Division of the Justice Department is known to be rough and tumble. They don't view themselves as prosecutors. They view themselves as lawyers with clients, like if you're a big law firm down the street here. Their job is to protect their client. They do not have the same sense of ethics and concern that a criminal prosecutor has in the criminal division or in a U.S. Attorney's office. The Civil Division people run roughshod over everybody on the other side of the case, and they defend vigorously to the point of, in my opinion, improper conduct, some of the things that they say and do in court. Let's remember, when that private email server was set up in Chappaqua, everything that went into it became the property of the United States government. Whether it was a personal email, a government email, classified, national, whatever it was, it belonged to the United States government. When Mrs. Clinton ordered the deletion of over 30,000 emails, that was a crime. She stole government property. Now, those deleted emails, it is my understanding, are being recovered. They're not even part of this litigation. Nobody knows what's in those 30,000. She has said they were personal. Guess what? She considers the Clinton Foundation to be personal. That's what's in there. It's Clinton Foundation stuff. And the fact that FBI agents are now assigned to, first thing they're told is read Clinton Cash, the book, and then come and start your investigation. Start looking at Boeing and what Boeing did to get a multi-billion-dollar contract. Now, it is very important to understand that the people in the criminal division, if they're doing their job, will not care what the civil division said. And when the FBI shows up at their doorstep with a prosecution memorandum recommending charges, they will have to make an independent judgment. But it will not be clouded by the type of representations made by the civil division in court. What the civil division is doing in your case and others, they're gaming. This is what lawyers call gaming. They say things because they have to. They don't say things because they believe them. They'll go to the edge. In these cases, though, with you, there's a duty at a certain point as a civil lawyer to know whether or not your clients are lying. And you don't turn in your brain at the door when you become a civil division lawyer. And all of your instincts about why clients lie and how they lie are supposed to be brought to bear on judgments about a case. When Jason didn't get answers 4 years ago from some inquiries, remember, the State Department was asked to answer some questions. Do you have these records? They didn't provide any answer. Now, why do you think they didn't provide an answer? Because they didn't want to lie. Because they knew about the server. People all over the State Department knew about the private server. Patrick Kennedy, who is, believe me, when you're looking for the bad guy in this story, there's only one bad guy. It's Patrick Kennedy, the Undersecretary of Management. He's the hitman. He's the guy who destroys people's lives in the State Department if they become whistleblowers. He ruins people for a living. That's what he does. And he hooked on to the Clinton train, and he did everything he could to protect her. I would love to be present for his deposition. I would love to be present. One of the fascinating things about the server, the private server, is here you have a series of House investigations. The Senate didn't do anything. I mean, I don't know what the Senate is doing. The House of Representatives had an Armed Services Committee, Foreign Affairs Committee, Government Oversight, and the House Intelligence Committee. 4 investigations. Now, they subpoenaed and asked for records. They got stonewalled. Some of them didn't even subpoena records. They just sent letters requesting documents. Not one of those committees, prior to the Benghazi Select Committee, knew that Hillary Clinton conducted her business from a private email server in her house. Now, what do you think of the quality of that investigation? Can you imagine John Dingell or Henry Waxman not finding out about the private server while they were dragging people up in front of their committees in public grand juries? The Republicans who can, I'm a Republican. I'm a conservative Republican. My wife, Victoria, with whom I practice law and who was in government, we're conservative Republicans. The incompetence of the House Republicans in conducting these investigations about Benghazi and related matters is a disgrace. Every one of those chairmen should be embarrassed by the work that they didn't do. It's, apropos of Tom's comments, is it any wonder we're just finding out about this? I can't imagine the old tigers running the House and the Senate tolerating any of this for a minute. These people aren't fit to govern. They're unbelievable.
Do you think that, or can you explain the significance to you of Brian Pagliano being granted immunity? What do you think that this indicates?
Well, first of all, anybody who knows anything about, first of all, I've investigated espionage cases, classified information. I did the Pollard spy case. So this stuff is, this is not complex stuff. The guy who set up the server is the first guy you talk to. He's also not going to be the last guy. He's also not the mastermind. He did what he was told. He's like one of the soldiers, he's not a capo in the mob. The Clinton mob had this guy at the bottom. You immunize him, number one, no thought, doesn't even take 5 minutes to figure out you're going to immunize this guy. And you have to. What happened was his lawyers went in and they made what's called a proffer. The prosecutors said, yes, we'll give him immunity, but you've got to give us a proffer off the record about what he's going to tell us. They heard it, they gave him immunity. Now, in all likelihood, he got statutory immunity, which means they went before a federal judge, they got the immunity, and you do that when you have a grand jury. If there's not a grand jury in this case, I mean, I don't know what these people are doing.
Can you explain statutory immunity and why that would, why
Well, statutory immunity grants you complete, Ollie North got statutory immunity from the committee. Remember when he testified? And Brendan Sullivan, his lawyer, said, whatever you do, say as much as you can, because once it comes out of your mouth under statutory immunity, they can't use it for leads, they can't do anything. And as you know, Ollie North was subsequently prosecuted by a mad independent counsel, convicted, and his prosecution was later thrown out because the court said there's no way after giving that testimony he could be prosecuted. That statutory immunity protects Brian Pagliano from everything, from any prosecution. He can never be prosecuted, state or federal, unless he lies. And then he can be prosecuted for perjury. The immunity is vitiated, and he can be prosecuted for everything up to that point. So if Brian is a smart little boy, he'll tell the truth, and he'll tell everything, and not try to hide or protect anybody.
Since you're making predictions today, I wonder if you could speak about how widespread you see these indictments, these potential indictments being, given that, as we saw with the Washington Post report, Clinton herself sent, I believe, 104 of these now classified emails, but there's hundreds of other officials who sent information that's classified as well. And then if I could just, one other question for the entire panel, which is how much of this, if we go beyond the Clinton email specifically, is an issue of FOIA regulations struggling to keep up with new technologies, and the laws not explicitly pertaining to not just email, but even newer technologies that are emerging and that aren't necessarily being incorporated into the archiving regulations, and I guess sort of how this can be exploited by government officials to circumvent FOIA.
Well, let me just say, the circle of figures at the center of the investigation includes Mrs. Clinton, Mr. Pagliano, Huma Abedin, Patrick Kennedy, Cheryl Mills, and several other people in the immediate circle. Those people all would have been privy to the fact that there was a private server and nothing else. They would have known that the private server was not encrypted because they were using private unencrypted devices to communicate with Mrs. Clinton through the server. Every one of those people who has a high-level security clearance is a potential criminal target in that inner circle. Beyond that circle, as you get farther away, people's culpability goes down because they're not going to have the type of knowledge about the original sin that they're not necessarily. They may see a Clinton.com. They don't know about that server in Chappaqua. If you know about that server in Chappaqua, you're dead meat. You are criminally responsible for the mishandling or the improper storage of classified information. That doesn't mean it's a felony. I want to underscore, if I were the FBI, I would recommend felony prosecutions for everyone in that inner circle, but I would expect a misdemeanor plea or a workout. And that would be my assumption. Once you get beyond that core, it's much more difficult to accuse people of mishandling when they're being sent emails from the inner circle. What do they know? How much do they know? Now, I have to tell you something. If I'm communicating with the Secretary of State and her entourage, 4 or 5 people tops, and it doesn't have a .gov on it, the first thing I'm thinking is, what's this all about? You don't have to be an expert. You don't have to have a degree in technology. You don't have to be somebody who's set up systems, who can write code and software. That is a fundamental. If you're getting, let's say you're getting sensitive information about what's happening in East Berlin after an attack, And you're on the periphery. You may be in the security people at the State Department who provide protection for Mrs. Clinton. And you get a .com email with some information about an attack. You know the first thing you do? You call somebody up and say, what the hell is this? Why is this not coming to me on a .gov? It would have been rudimentary for people to ask the question, what is this email stuff? And a lot of people didn't. And so the question is, why? Because they were afraid to. Because you never crossed the secretary and you never crossed Patrick Kennedy. Well, back in December when I started talking about this, and then everybody sort of piled on and information started coming out as a result of that, I predicted 60 to 90 days for a recommendation from the FBI to the Attorney General. I had no idea when indictments might come, if any, because that would require review. And the FBI could make a recommendation without a grand jury. But there's no way you give Brian Pagliano immunity without having subpoenaed documents from a bunch of third parties. And you only do that with a grand jury subpoena. So now that they've gotten into the Clinton Foundation, and we know that there are several dozen agents assigned to the Clinton Foundation, and whether or not their official acts were bought and paid for by donations to the Clinton Foundation, it could go on longer. But the pressure to decide sooner rather than later, I would assume by May there's going to be a recommendation from the FBI, certainly before the Democratic Convention, and there should be. I mean, she has a right to know whether or not she's in trouble, and the American people who might be voting for her, especially Democrats in primaries, certainly have a right to know whether or not this is all for naught.
Well, would a special counsel start from scratch if he or she were appointed?
Well, if they appointed a good special counsel, in other words, someone who'd been a U.S. attorney before or a federal prosecutor before, someone these are not complex matters. I think the Clinton Foundation issue, whether or not official acts were bought and paid for with donations to the foundation, that's a more complex subject, but the evidence is already readily available. If you appoint a special counsel, that person has to get organized, get an office, hire staff. So it would obviously elongate the decision process about whether or not to charge her or anyone else. Well, what's going to happen is, because of your depositions and your questionings, obviously this issue is going to come up, and the question, I would assume, would be asked, where are these other emails? Were they destroyed? Were they placed in another server? Were they printed out? Are they in electronic form? I mean, the notion of turning over to a journalist tens of thousands of pages of documents with no electronic format for searching is ludicrous. The only reason you do that is because you don't want the reporter to find anything. That's why you give them paper. It's the old trick in litigation. You dump 2 million documents on your opponent and let them see if they can find anything. In this case, unless people are prepared to lie for their leader, I would assume that the answer to the question about where are these other emails and whether or not they are truly personal, I'm making quotation marks with my fingers, will come to light, and no doubt as a result of the varying litigations